Welcome to the DGA Deal Unpacked, What Attorneys Need to Know. I'm Keith Kelly, Chair of the Beverly Hills Bar Association's Entertainment Law Section. The Entertainment Law Section is graciously sponsored by Lawyers Mutual Insurance Company. Please see the chat and written materials for more information. I'm excited to introduce today's speakers. Dan Stone is a partner at Koff, McGuire, and Margolis LLP. He is a litigator and trial lawyer who specializes in representing media companies in their dealings with the entertainment unions. Before joining KM&M, Dan was a partner at Greenberg Glusker, and he's previously served as an assistant general counsel at the Directors Guild of America. He has been quoted in the New York Times, Los Angeles Times, Washington Post, and Variety. David Schraga is a mediator and arbitrator specializing in the entertainment and intellectual property with additional experience in complex business and employment litigation. Over his 20 plus years practicing in LA, he has worked as both a litigator representing artists and a range of other clients, and as an in-house lawyer and studio executive. Most recently, he was the head of global TV, business and legal affairs for Miramax, and he also serves as part of the leadership team of the entertainment law section of the Beverly Hills Bar Association. And now let's get started.
All right. Well, thank you, Keith Kelly, for your very gracious introduction. Dan Stone, it's a pleasure to be here with you today as well.
Hey, nice to see you, Dave. Thanks for
Thank you.
having me.
Dan, you are a true expert, subject matter expert in this area. Obviously, you've got the background at the DGA, you've got the background in private practice representing lots of producers and others, and you also have really fantastic expertise handling arbitrations within the guild system as well. So I think your perspective on the front end and the back end is going to be really useful for our audience here today. So Dan, we have half an hour to cover the highlights of what was agreed to in the latest WGA agreement. And of course, for those who follow the news, I think our timing is a bit fortuitous today. There's been some big news as well.
Yeah, that's right. Well, first, this is going to be a sprint, not a marathon. So happy to be sprinting with you, Dave. And then,
Sounds
yeah,
good.
the SAG and the producers just announced that they reached a deal over the weekend. So if there's enough interest in this, we can do another one of these for the SAG agreement in the coming weeks.
It would be a real pleasure to do that, of course. And yeah, we're gonna sort of do a lightning round. I think we've got about 8 different topics we're going to try and cover today, from what's going on with the health plan to the term of the deal to some new AI issues to be thinking about. And so, if you do the math, I think we probably got about 3 to 4 minutes per topic. I've got a buzzer here, Dan.
Uh,
Should we
uh,
use that,
uh,
or should we stay away from it? Do you
you,
feel the
you can
pressure?
you can buzz me all you want.
Okay.
Let me just start out with because Dave, obviously you have substantial experience in the entertainment industry, first as a litigator, then as an executive. So before we dig into too much jargon, I just wanted to give a brief overview for the people who may be listening to this, who may not be as uh, chest deep in entertainment as we are, right? So the Writers Guild of
Yeah.
America produces represents American writers, right? They're a union that represents American writers primarily in film and TV. That's what we're going to be talking about today. And if you're a writer who qualifies, a working writer who earns enough money, you get your health benefits and are eligible for a pension plan that's administered by a separate but related entity, the Writers Guild of America Producers Pension and Health Plans. So you're going to hear Dave and I refer to the WGA, that's the Writers Guild, and to the plans, that's the pension and health plans. Um, the other thing to note is that these negotiations that we're going to be talking about are between the Writers Guild and an organization called the AMPTP, which is basically an umbrella organization of the major movie studios and streamers. So that's who the parties to the negotiation are. Those are the people who form this contract. Just before we go into the details of the health plan, these contracts are usually for 3-year cycles. This one is for a 4-year cycle, and we're going to get into that in a minute as well.
Okay, great. And we're obviously in this negotiation cycle, and when we talk about the major guilds, we're looking at not only the WGA but the DGA, and you mentioned SAG has just reached an agreement with the AMPTP. Dan, big picture, I think it was important, I think, to to try and convey that these negotiations really tend to follow a cycle, right? And they have a rhythm of their own. And what is your perspective on overall where we are in the negotiation cycle between the guilds and the studios right now, especially after coming out of a negotiation 3 years ago that led to strikes and really had a massive effect on the industry and recalibrated things?
Right. I mean, so it's very typical in these negotiations to have sort of substantive changes. And of course, 2023 had big substantive changes, two strikes. And then the cycle after that are sort of minor tweaks and oftentimes an effort to make sure that the pension and health plans in particular are appropriately funded. So it's no surprise that this round has really focused, at least thus far, on making sure the health plans are in good financial shape and that riders continue to be able to get their health coverage through those ERISA plans.
Okay, fantastic. So we're really talking about not as much a wholesale revision as a fine tuning that's going on through this latest cycle. So let's start talking about the health plan. For those in our audience who heard Ken Ziffrin speak to the Beverly Hills Bar not too long ago, he flagged that this issue was coming. And obviously, when you're talking about Ken, it's not a question of whether or not he was right or wrong. It's just a question of how right he was, right? So, Dan, what is your take on what's going on with the health plan rehabilitation, and what are the key takeaways for our audience here?
Yeah, so it's been widely reported that the WGA plans experienced significant losses in the past couple of years. They had reported losses of over $100 million. And this deal, at least based on what has been put out there, is projected to infuse about over $320 million into the WGA health plans. Now, the provisions of the agreement and what's really important to producers is that this is going to happen two ways. One, it's going to increase the rate of contributions. And two, it's going to increase the cap on contributions, right? So I'm just going to get into a little bit of details and then we'll be able to move forward, right? So it used to be a number of years ago, people would give a rule of thumb. They would say, whatever you're paying to the writer, you're budgeting an additional 20% for pension and health contributions. So you pay $100,000 to the writer, you're going to pay an additional $20,000 to the pension and health plans. That number went up to 25%. And then under this contract, it's going up to 28%. So the 13% contribution to the health plans is going up to 16.25%. And then by the end of the contract, it's going to be up to 16.75%. Then the other aspect is, okay, 28% of what? And so for those of you who've been dealing with this for a while, there are always caps, right? If you're paying a showrunner $5 million, for example, you're not paying a full 20-something% of that as pension or health contributions. So those caps are now in basically three different tranches. One is the theatrical cap. If you're hiring a feature screenwriter, it's going up from 250 to 325. And then by the end of the contract, it's ultimately going to go up to 400,000. There are two new categories of caps for pilots. I'm not going to get into that. And then for Article 14 writers and producers, the pension amount is going to stay the same, but the health amount is going to go up, right, to 275,000. It's going to go up to 325, then again to 375, and again to 400. So again, you're paying a higher rate on a higher cap pretty much across the board. So you have to budget more for those contributions.
Okay, so we're seeing a big move here is adding to the overall cost of these deals, of course, but this is really what was necessary to shore up the pension and healthcare plans here as well. I mean, big picture, right? What motivates it? What's the impact? It really shows the interdependence between the studios and the guilds, I think, and the cost of insurance going up, more people, right, on the rolls, but also that there's fewer people being hired in some sense, right? In terms of, the businesses constricting, so there's a bigger pressure, but less potentially to draw on for it.
Yeah, I mean, without getting into too much detail, anytime you have an ERISA plan, and particularly these sort of legacy ERISA plans, There's always the issue of providing ongoing health care, people who have qualified and then may not be working, and obviously costs going up. So they need to make sure there are enough contributions going in that will continue to fund the health plan going forward. And that's really the focus of this round of bargaining.
Okay, great. Well, I'm sure there's lots of people who are sleeping easier knowing that this issue has been addressed as well. Okay, so let's get into the next category. And by the way, that's probably on pages 10 through 13 of the MOU for folks who are going to be trying to follow, and I think those materials will be available as well. So another big change, we're used to three-year deals, but as you mentioned earlier, we're talking about a four-year deal now. What's the key takeaway, and how does that affect what the overall number, how the overall numbers have shifted?
Yeah, so it's just that. I mean, and for generally speaking, there are some exceptions, but it's 4 years. Typically under these CBAs, there's sort of an average or customary increase of 3% a year. Last bargaining cycle, the gains were more than that. This time it's 4 years starting at 1.5% the first year, and the following 3 years are each 3%, right? And I think it reflects two things. The 1.5% the first year really shows there is a very heavy emphasis on having more compensation and contributions going to the health plans. And the 4 year duration basically shows, there's a new regime at the AMPTP. They've focused on these longer contract periods. And this basically gives a greater period of stability, right? There's an additional year to get to negotiations. And really for the producers, both the studios and the independents, this gives them a 4 year period of understanding what their costs are going to be, and one more year that they know there won't be any sort of negotiations or potential work stoppages. So I think that certainty is probably good across the board for the industry.
Yeah, I think it lets people sort of catch their breath a little bit in between these negotiations. I mean, some of these major studios have so many guild agreements that are in place, not just below the line, above the line, but below the line as well. You're kind of constantly in negotiation. So I imagine this alleviates some of that pressure. Plus, these deals are getting more and more complex, right?
Yeah, I mean, when the 3 year cycle started out, I have a slide that I use in a presentation I give to people. When these deals started out, they were like pamphlets, 20 or 30 pages, and now they're hundreds and hundreds of pages. So they're exponentially larger. And then, like you said, Dave, the what are called the above the line unions negotiate this year, SAG, the WGA, and the DGA. And then next year, there are below the line unions, IATSE and Teamsters. So it's almost a never ending cycle. This creates a little bit more space.
Sounds good. And of course, I mean, even though it's a four-year deal, the guilds and the producers and the members, they're constantly in dialogue, right? I know that, there's AI issues and things are constantly changing in the industry, but there are internal mechanisms, right, to foster ongoing communication.
Yeah, I mean, and you mentioned I handle a lot of arbitrations in this space. There are all sorts of formal and informal discussions that go on. There are arbitrations that come up. The AMPTP and the individual producers and the guilds are in constant communication. There are also a number of provisions in the collective bargaining agreements that expressly call for a dialogue or regular meetings, and that certainly happens.
Okay, fantastic. So, moving on to our next topic, general wage increases. And I think we did talk about this generally in terms of what we're looking at overall, 10% over 4 years. One thing I think is worth noting is that there was a big overhaul, like we said earlier in 2023. But again, these are really sort of incremental increases, right? That we're seeing. A lot of times people look to these guild agreements and they say, what's going to be the next big structural change to deal with how the industry is shifting? That's not really what we're talking about in this cycle, is it?
No, 3% has typically been, I would call the cost of living increase. That's pretty much, standard for these agreements. Sometimes it deviates. Last cycle it did, but now we're sort of back to this cost of living increase.
Okay, great. So then why don't we move on to the next topic here, which
Yeah,
is
yeah, electronic service. I'll just address it, Dave, since this is my pet peeve. It's really, for the studios, not a big deal, but this is one of these provisions that the studios negotiate and then the independents really have to live with, right? So it's sort of an afterthought. Now, when you enter into one of these agreements, an independent producer usually signs what's called a letter of adherence. They're going to have to designate an email address for service of process or any notices under the guild agreements. And especially for smaller independent producers, oftentimes what they do is they don't really think about this. They'll put down an assistant or they'll put down some random email address. And if you're going through this process right now, if you're filling out your signatory application or you're getting an agent for service of process, please spend 5 or 10 minutes thinking about it, because this is the way that you will get claims from the WGA. If you get an audit notice from the WGA, or even if there's just some inquiry saying, hey, we need this additional information, please make sure you spend the time and actually think about who's going to respond to it, whether it's a producer, somebody in-house who you think is actually going to be there, or an outside attorney, or even a business manager. Just make sure it's somebody who's responsible, who will understand what they're receiving and be able to transmit it to the right person. I know it seems sort of rote and mundane, but trust me, it becomes important. And I've dealt with all sorts of clients who just ignore these things, and there can be real consequences to that.
Yeah, I mean, we're talking about potential loss of consideration for awards, right? Penalties, things like that.
Yeah, I mean, I've dealt certainly in the Producers Guild context. I've seen people who just don't respond to Producers Guild inquiries about awards, and they've, missed out on things like that. But for all of these notices, but particularly now where they're saying, we're not going to send you something in the mail anymore, we're just going to send you an email, just make sure the right person is getting that email.
Look, I think it's an important point, coming from the studio side for many years. I mean, when you're at the big studio, of course, there's a central repository for all this. It goes straight to labor, right? And they're all constantly speaking with each other. Things don't get lost as easily. But at smaller places, it's often the case that it may take, weeks, often longer, before you get a notice. And from the business and legal affairs perspective in-house, typically the last thing you want to do is be sideways with the guilds, right? And not
Right.
be in a place
The
where
the
you're
other
disappointed.
point the other point is just for people who aren't that experienced, right? You sign an agreement now, and sometimes you don't get a notice until a year or 18 months later, right? So it's just important that somebody is going to be there to answer that request, because whether or not you respond, that service or that notice is going to be effective.
Yeah, it's a bit of a hidden landmine. And I imagine for foreign producers, it's particularly important for them to keep this in mind as well.
Yep, absolutely.
All right, so let's talk about page one rewrites. Why don't you define what this is for folks and tell us what the key takeaways are
Yeah,
here?
Yeah, so it used to be the old categories are this is for theatrical screenplays. It used to be you would write, an original screenplay or a screenplay with a treatment, and then there were different rates for draft screenplays and polishes, right? So the highest was for a screenplay. Then for about less than half than that, you could get a draft or a revision, and then for about half of that, you could get a polish. Now there is a new category called a page one rewrite. And what that is defined as the making of revisions or modifications when the writer is directed by the company to replace all or substantially all of the existing screenplay, right? So really this is a second tier, right? So the minimum under the current agreement for a screenplay without a treatment is $102,000. This creates a page one rewrite level for about $57,500, again, for a high budget. So that's sort of the second tier. And what you can assume is that, there's now going to be more people advocating for, hey, I'm really preparing a page one rewrite, but also if you're assigning a writer a page one rewrite, basically keeping the idea but completely changing the screenplay, the minimum is going to be higher. Now, functionally, a lot of people who do page one rewrites are going to be paid well above that minimum, but it does create a new minimum, particularly for independents who are going to hire for page one rewrites.
Yeah, and I think it's helpful because it sort of codifies a conversation that's happening anyway, right? Because when you're negotiating with the reps for the talent and you're bringing on a writer, the reps are often saying, we understand from our client that this is really going to be a page one rewrite, right? And it's the basis for advocating for more for their client. And the flip side is you're talking to your creatives about really how much of a change we are looking for. So I think having some parameters around that is going to be helpful for folks who are in this conversation.
Yeah, and look, on the back end of things, if you pay someone for a draft and the writer thinks that it's a page one rewrite, the writer may ultimately go to the WGA and say, "Hey, they paid me scale for a draft. I had to do a page one rewrite." That gives the WGA the ability to grieve and seek more money. So, it's a conversation that, like you said, is better to have up front, but it gives recourse in case someone advertises something as a draft, but actually requires a page one rewrite.
Got it. And of course, this doesn't have any impact on credit determinations. It's really just a function of defining what you're going to get paid for the piece of writing.
Yeah, the credit determination process is going to remain the same.
Okay, great. So let's talk about SVOD residual increases. That was a big topic the last time around. There was a lot of dialogue, streaming residuals and talent seeing their work up on these streaming platforms and feeling like they weren't compensated. What's the latest installment in this saga?
Yeah, so again, the same way that we talked about the wages are effectively a more standard cost of living increase, right? The SVOD residuals increases are pretty much the same. It's a 4-year cycle, and there are two increases, an approximate 2.5% increase in year two, and then an approximate 2.5% increase in year four. The only difference is there's an additional increase that's tied to foreign subscribers for what's called a tier four service. Now, if you have over 75 million foreign subscribers, there's going to be additional increase. But really, this is just, again, that sort of regular escalation of the high budget SVOD residual.
Got it. And so from the producer and studio side for streaming in particular, you're often just seeing the streamer covering these residuals anyway, so it doesn't necessarily have a huge impact, I would say, on the producer's end of the spend, although it increases, overall costs, of course. But I think there's something interesting that's baked into this, Dan, and this goes back to the first thing we were talking about, which is rehabilitating the funds, right? So why don't you speak to that?
Yeah, I mean, every bit of compensation gives rise to pension and health contributions. So a portion of your residuals are going to go and again fund the plan. So it's just if you're sort of looking at what's the overall motivator, a lot of the motivators here are they want, increased rates, increased money to go into the writer's pocket, but also there's a strong focus here on more money into the pension and health plans, and particularly the health plan.
Right. So it's really just one more way to continue to shore those up. Okay, so this is a really interesting topic here. Residuals for writing that is based on underlying source material. Why don't we speak to sort of what the takeaway is here and how things have changed in terms of how writers are being paid residuals when there is underlying material as the basis of their work?
Yeah, so until this change, there was this issue that you could only qualify for a full television residual if you received written by credit, right? Effectively, you had to have both the story and the writing credit for an episode, right? And that what that did is that created a system where oftentimes writers who are writing based on source material were not getting the full residual. This now creates a system where you can get the full television residual even if you don't get the written by credit, right? So you can get a what's called a telepay by credit or written for television by credit. And as long as no other writer gets a story by credit or an analogous television story by credit, you can still qualify for the full residual. So
And
just sort of big picture, right? There is not a disincentive, but it's sort of a recognition that increasingly a lot of the series out there are based on source material. And so those writers are effectively going to be eligible for the same residual as somebody who's writing a fully original series.
Yeah, it's a really interesting nuance within the agreement, I think, because typically when you're thinking about source material, let's say from a studio or a deal maker perspective, and when you're dealing with the reps, it's usually a question about, is a created by credit going to be available, and how is that going to affect potentially the availability of separated rights? But we're really talking about not just that consideration, but also the residuals that are going to be payable, not just for the pilot, but for all the individual scripts. And I mean, effectively, you're going from 75% to 100%, right? So we're really talking about something that is more significant, I think.
Yeah. Yeah, and that's Dave, I have my old copyright professor included a question in the chat, so I'll just answer.
Okay.
He asked how the SVOD residual is measured or calculated. The SVOD residuals are effectively flat fees, so it's almost in a certain way based on the old run-based residual. It's not like a theatrical residual. That's a percentage of gross. Um, let's go back to what we were talking about. I just figured I owed Jay Doherty a response. So
Okay. It's always great to have his participation. Okay, so I think our final issue, we saved a few extra minutes, is the AI training disclosure that is now part of the WGA agreement. This is something we haven't seen before. It's an extension of the conversation around how AI is affecting the industry. What has been agreed?
Yeah. So, and again, just I'm going to address this, but also address a couple of the issues that came up in the chat, right? So, again, this AI provision, like the rest of these provisions, are between the producers and the WGA. This doesn't really address what writers have to do, and it's really this contract is focused on film, TV, and high budget SVOD or SVOD, right? So streamers like Netflix and Disney Plus, right? So it's not for generally for podcasts or other things like that. Oftentimes animation has separate agreements, right? But what they included here, and we remember from the last cycle, there were extensive provisions addressing AI. This has an additional specific provision that says that effectively a producer has to disclose to the Writers Guild when they are licensing material to a third party for AI training, right? So if you're basically licensing screenplays or teleplays or even treatments to even whether it's a chat GPT or some much smaller AI, sorry, open AI or a much smaller AI provider, right?
Mhm.
You have to disclose that to the Writers Guild. And we can talk about what the import of that is.
Yeah, I mean, we're talking about effectively the guilds want to know what the studios are doing with these materials in terms of licensing it for training. And also, I presume the disclosure includes the revenue that's associated with this as well. And I think it's probably a first step along a road towards trying to have a conversation about how do the guilds participate in the monetization of these materials for training.
Yeah, I mean, so I think certainly all of the guilds are looking at potential revenue sources, both in terms of payments to their members and potentially to fund the pension and health plans. This basically says, hey, you're going to disclose it to us when you're licensing, our members' content to AI for training purposes, right? And then effectively there's going to be a conversation going forward. This really just starts the process. There's no mandatory compensation here. There's generally no mandatory compensation for most of the AI provisions, but there's going to be a process of discussion. For those of us who've been doing this for a while, it was a similar process when streaming started, right? There were various iterations of the streaming provisions. Streaming was originally very different. There were talks about what happens if you have these mini episodes on the web that evolved into, the bigger streaming services. And, I think AI is probably going to evolve in a similar way as the ecosystem grows. But if you sign up for one of these agreements, you're probably going to have disclosures about how you use AI. That's going to carry over to a lot of the different types of agreements as well. It's already really in, commercials, in video games, in all of the different types of agreements that are out there. And that's just going to continue to be the case.
Yeah, I mean, we see this evolution of a licensing market that didn't really even exist, let's say 3 years ago, the last time these negotiations are ongoing. We've seen authors starting to license their work for training. We've seen lawsuits about it, obviously. Some of the periodicals out there, clip art. So it's sort of a new frontier in terms of how to exploit these properties. But what it isn't is sort of like a wholesale ban on training, right? We know that lots of reps when they're negotiating these agreements want to sort of have limitations on how their clients' materials can be used for training. But for the time being, all these things are still negotiation points.
Yeah, I wrote an article about the SAG AI provisions a couple of years ago when it came out. And, I think the argument still holds where, when there was resistance to studios basically using film materials for AI training or sort of leveraging them to negotiate with the AI companies, the pushback was, well, otherwise they may get them for free, right? And they're out there scraping the web, they're scraping social media, right? We know from the AI cases now that um, the AI companies have generally trained on published books, even from large, book publishers. So, the studios are going to try to find a way to potentially monetize this in one way or another. And the guilds are basically saying, okay, maybe, but we want to know about it. You need to let us know when you're licensing the material.
Yeah, everybody wants a seat at the table as this evolves. Dan, we're at the end of our time. I'm not sure if there's anything else that you saw maybe in the chat that you wanted to address, or if you wanted to read any tea leaves about the SAG agreement and what's coming. One of the things that's come up is that there's going to be new AI provisions in that agreement as well. So I imagine it's probably some things are going to track what we've been talking about and some new areas to consider.
Yeah. The other thing based on some of the questions, the other thing that I just want to bring up is these agreements are a contractual floor, right? You can negotiate above for increased terms. And, we know, Dave, that's part of a talent lawyer's job or an
Of
agent's
course.
job is to get more than the minimum and all sorts of terms that are better than the guild agreement. But you can't negotiate below the minimum. That being said, there was somebody who put a question about, well, can I negotiate to not have my written material be provided to AI? The answer is, for the most part, going to be, I would guess, no. I think unless you have a lot of leverage, but even so, I think really it's important for people to know that the AI companies are out there really collecting all of the material they can get their hands on, even through means that, the entertainment industry oftentimes believe isn't above board. So, you may be fighting a losing battle to keep your material off of AI completely. And maybe the best possible outcome is to potentially get some money out of it, or at least potentially some money for the pension and health plans. But
So,
I'm getting out over my skis that none of that has happened yet.
well, it is to be continued, Dan, and we'll see what happens as the business continues to evolve and move forward. I think we did it. We're at the end of our half an hour. Thank you so much for your expertise and for running through this all with us. I think for practitioners and on the talent side, for folks who represent producers, for folks at the studios, it's been a really helpful primer on the things that we need to be thinking about moving forward under this new agreement. So thank you.
Yeah, yeah, and I'll just throw in one other thing. For people who are producing episodic TV or high budget SVOD, there are a number of changes in the last agreement. There are some minor tweaks that are made in this agreement that would be too detailed to go into. So, speak if you're a business affairs executive or a lawyer who's dealing with productions, go speak with your labor relations department or your outside labor counsel, and they can sort of run you through the changes for your TV series agreements.
Great, Dan. I think we're there. Thank you so much. I'm going to give it one more final buzz here, and we'll be talking together again about the next agreement that's been ratified.
Thanks a lot, Dave. Always a pleasure speaking with you.
Likewise, Dan. Thanks, and thanks to our audience and all of our sponsors.